This morning, the Supreme Court has delivered a monumental victory for the Constitution, the separation of powers, and the rule of law in striking down the excessive use of nationwide injunctions to interfere with the normal functioning of the executive branch. The Supreme Court has stopped the presidency itself. That's what they've done. And really, it's been an amazing period of time this last hour. There are people elated all over the country. I've seen such happiness and spirit. Sometimes you don't see that, but this case is very important. I was elected on a historic mandate, but in recent months we've seen a handful of radical left judges effectively try to overrule the rightful powers of the president to stop the American people from getting the policies that they voted for in record numbers.
The Supreme Court's emergency docket, also called the shadow docket or the interim docket, is for, well, emergencies. This is every time the federal government had a case there, back to the first Trump administration. And here's just 8 months into his second term. It's being used in record numbers.
Emergency applications used to be a very, very small and not especially divisive part of the Supreme Court's work. Now, this is the front lines.
Not only are there more of these cases, but President Trump is winning more than his predecessors have. And we don't really know why.
We don't know why, because with this shadowy process, the Supreme Court doesn't have to.
There is a quote from Andrew Jackson that has haunted American constitutional history for almost 200 years. When the Supreme Court ruled in 1832 that Georgia could not enforce its laws on Cherokee territory, a ruling that should have stopped what became the Trail of Tears, Jackson allegedly responded, "John Marshall has made his decision, now let him enforce it." He didn't say it exactly that way. Historians debate whether those words were spoken at all, or in what context, but the sentiment is documented. Jackson refused to enforce the ruling. The Cherokee were removed. Thousands died. And Jackson's defiance became the permanent institutional record of what happens when a president decides that a Supreme Court order is optional. The reason that story matters right now is not dramatic, it is mechanical. Courts do not have armies. They do not have marshals who can compel a president to act. When the Supreme Court issues an order, compliance depends on something the founders assumed would always be present and sometimes is not: the president's willingness to treat judicial authority as binding. When that willingness is absent, the Constitution has one remaining answer, and it runs through Congress.
Disaster. Nobody can believe these decisions we're getting from the Ninth Circuit. It's a disgrace. The Ninth Circuit, everybody knows it. It's totally out of control.
When Trump took office, most of the Ninth Circuit's judges had been appointed by Democratic presidents, and they overruled some of Trump's most provocative executive orders. The travel ban, emergency funding for a border wall, they all stopped here.
Very hard to win at the Ninth Circuit, if not impossible.
A big win for President Trump today as the Supreme Court denies Democrats access to grand jury material from Robert Mueller's Russia investigation, at least for now anyway. The court agreed to hear the administration's appeal of a lower court ruling that the documents be turned over to the House, which likely would not happen until after the 2020 election. House Judiciary Committee Chairman Jerry Nadler putting out this statement saying that he is confident.
I need to be precise about what is verified here and what this document is getting wrong, because one of its central factual claims is incorrect and it matters for the analysis. The document states that Democrats control the House. They do not. The Republicans hold the House with a 5-seat majority. This series has documented that throughout the accountability story. That factual error affects the document's analysis of how quickly impeachment could move, because articles of impeachment in a Republican-controlled House face a fundamentally different political pathway than in a Democratic-controlled one. What is verified? H.Res. 353 exists in the permanent congressional record, introduced with 7 articles of impeachment. Thanedar has introduced impeachment-related resolutions. The shadow docket analysis in the clips is accurate. Emergency applications to the Supreme Court are being used at record rates, and the court's process for handling them offers minimal public explanation. The constitutional analysis of the faithfully execute the laws obligation is sound, and the Jackson parallel is historically documented. What I cannot verify from available sources, the specific SCOTUS ruling on immigration policies described in this document, and Trump's specific public refusal to comply with it. Those claims require independent verification this commentary cannot provide. What I can address is the constitutional architecture that would make such a scenario significant if it were to occur, and the historical parallel that makes the stakes concrete. The thing about courts is that their authority is almost entirely moral. That sounds like a weakness. It is actually the most sophisticated institutional design the founders produced. By giving courts the power to interpret law without giving them the power to enforce it, the founders created an institution whose legitimacy depends entirely on the acceptance of that legitimacy by the other branches. The moment the president decides that a court ruling is advisory rather than binding, the court's power collapses, not because the ruling changes, but because the ruling's enforcement mechanism was always the president's own compliance. Jefferson understood this. Lincoln understood this. FDR pushed against it with his court-packing scheme and ultimately backed down. Nixon, facing the tape subpoena, complied rather than face the constitutional rupture of outright defiance. Jackson is the exception, and the Trail of Tears is what the exception produced. The constitutional remedy for a president who treats court orders as optional is impeachment, not because impeachment is certain, not because the Senate math makes conviction likely. This series has documented that 67 votes require 17 Republican senators from a 7-senator baseline after the second impeachment. But because impeachment is the only institutional response Congress has to a president who has placed himself outside the court system's reach, the document correctly identifies this. Courts can't physically force the president to do anything. That's where Congress comes in. That framing is constitutionally accurate. It is also why the impeachment discussion is inseparable from the court defiance discussion. They are not two separate stories. Defiance creates the constitutional predicate. Impeachment is the only available institutional response. The shadow docket dimension deserves direct treatment because it is one of the more analytically underappreciated elements in this story. The Supreme Court's emergency docket, the shadow docket, was designed for genuine emergencies. Requests for stays pending appeal. Urgent applications where irreparable harm would occur without immediate action. A small, discrete category of cases where the normal appellate timeline would cause real damage. 8 months into the second term, the government has been filing emergency applications at record rates. The shadow docket has become, as the clip puts it, the front lines. And because shadow docket orders are often issued without full briefing, without oral argument, and without written opinions explaining the reasoning, the American public, and often the parties, are left trying to interpret what the court meant from the result alone. That opacity matters because it creates interpretive space. When the court issues a full opinion with reasoning, the scope of the ruling is defined by the reasoning. When the court issues a shadow docket order without explanation, the scope is contested. The administration can argue that compliance means X. The petitioners can argue it means Y. And another trip to the shadow docket is required to resolve the dispute. This is not a theoretical problem. It is the operating environment in which the court and the executive are currently functioning. Record emergency filings, orders without explanation, contested compliance, and a president who has been across multiple second-term proceedings testing where the practical limits of judicial authority actually sit. H. Resner. 353 is the institutional anchor in this story that outlasts any single ruling or any single impeachment resolution. 7 articles introduced April 28, 2025 in the Permanent Congressional Record. Each article documenting specific categories of conduct that the resolution's framers assessed as meeting the high crimes and misdemeanors standard. To faithfully execute the law's obligation, Article 2, Section 3, is the constitutional provision most directly implicated by court defiance. The president is not merely permitted to execute the laws, he is constitutionally obligated to. Defying a court order is not a policy choice or an exercise of executive discretion. It is a failure of the specific constitutional function the office requires. That constitutional argument is why the defiance scenario, if verified, would represent a qualitatively different impeachment predicate than the ones that produced the first and second impeachments. Ukraine involved disputed facts about a phone call. January 6th involved disputed interpretations of a speech. Court defiance involves a specific, documentable, legally unambiguous act. Receiving an order, knowing it is an order, and refusing to comply. The Jackson parallel is instructive precisely because it was not ambiguous. Jackson knew what the court had ruled, he chose not to enforce it, and the historical judgment on that choice, 2 centuries of condemnation, the Trail of Tears as the documented human consequence, is what makes the precedent so vivid. The question the current accountability story is building toward is not whether court defiance is impeachable. It clearly is. The question is whether the political conditions exist to convert that constitutional predicate into a Senate conviction, which requires, as this series has documented throughout, 17 Republican senators willing to cross the threshold that produced 7 in 2021. November 2026 is still the specific mechanism that either changes that math or confirms it. One thing worth sitting with before I go. The document ends with this framing. If Trump gets away with defying the Supreme Court, the Constitution is just a piece of paper and presidential power is unlimited. That is too simple. The Constitution is not a piece of paper when it is defied. It is a piece of paper when it is abandoned by the institutions that give it meaning, not just by one president, but by the Congress that fails to respond, the courts that cannot enforce their own rulings, and the electorate that decides it does not matter enough to factor into its vote. The constitutional structure the founders built is resilient but not self-executing. It requires active participation from all three branches and ultimately from the people who choose the people who staff those branches. One president defying one court ruling does not end the Constitution. A pattern of defiance met by institutional silence might. That is the honest stakes. Not democracy dies tonight. The slower, more patient question. Will the institutions respond? Will they build the accountability record that creates consequences? And will November 2026 produce the electoral environment where those consequences can be executed? That question does not have a dramatic answer. It has a November answer. Commentary based on confirmed HRES 353.7 articles, April 2025, documented throughout this series. Confirmed Thanedar impeachment resolution documented throughout this series. Confirmed shadow docket record emergency applications verified. Confirmed courts lack independent enforcement mechanism. Constitutional analysis accurate. Confirmed faithfully execute laws. Article 2, Section 3 obligation verified. Confirmed Andrew Jackson Worcester versus Georgia 1832 defiance historical precedent verified with accuracy. Note the exact quote is disputed by historians. Confirmed 17 Republican senators needed 2/3 threshold documented throughout this series. Confirmed 7 Republican senators second impeachment conviction baseline verified. Confirmed 5-seat House Republican majority documented throughout this series. Note document incorrectly states Democrats control the House. Confirmed November 2026 mechanism documented throughout this series. Note specific SCOTUS immigration ruling and Trump explicit public refusal described in document not independently verified and treated as constitutional architecture discussion rather than verified current event. The immigration enforcement dimension deserves more direct treatment than the document gives it, because this is where the human stakes of the court defiance scenario become concrete. The cases the document describes, people deported before receiving their required legal hearings, asylum claims ignored, individuals removed in violation of their documented legal rights, describe a specific category of harm that is not abstract. These are people whose cases the legal system had not yet resolved, who had pending claims that entitled them to process, and who were removed before that process occurred. Courts ordering the administration to make efforts to return those individuals is not the court legislating immigration policy. It is the court enforcing the procedural requirements that Congress already legislated. The distinction matters because one of the administration's arguments is that courts are overstepping by directing executive enforcement priorities. But when the enforcement action itself violated statutory procedural requirements, when someone with a pending asylum claim was deported without the hearing that statute requires, the court is not directing policy. It is enforcing the statute as written. That is the constitutional space where the defiance scenario has its clearest legal grounding. Not you must prioritize these cases over those cases, which would be directing prosecutorial discretion. But you cannot deport someone without the hearing the statute requires them to have, which is enforcing a statutory procedural right that Congress created and the executive is obligated to follow. The Jackson parallel maps onto this precisely. Jackson's defiance was not about broad policy. It was about a specific court ruling on specific legal rights of specific people. And the human consequence of that defiance was the Trail of Tears. If the immigration court defiance scenario described in this document is verified, the human consequences are not Trail of Tears in scale or character, but the constitutional structure is identical, specific court ruling, specific legal rights of specific people, president deciding the ruling is optional. That structure is what makes the Jackson parallel analytically apt rather than rhetorically excessive. The courts see this. That is why the shadow docket has become the front lines. Both sides are using emergency applications because both sides understand that speed matters when the human consequences of any single ruling are immediate and potentially irreversible. You cannot undeport someone who has been killed in the country they were fleeing. You cannot restore the months or years of legal process that were bypassed. That irreversibility is part of what makes the court defiance scenario constitutionally distinct from other forms of presidential overreach. A president who overspends his appropriations can be corrected by a future Appropriations Act. A president who deports people who should not have been deported before their cases were heard may have created a harm that cannot be corrected at all. And one more thing that I keep coming back to. The document asks whether we are a nation of laws or a nation where the president can do whatever he wants, regardless of what courts say. That binary is too clean. Most constitutional crises do not resolve cleanly in either direction. What actually happens is messier. A president pushes, courts respond, Congress debates, the political environment shifts, and the system adapts in ways that leave the constitutional question answered but not resolved, answered in the specific case, unresolved as a precedent about what future presidents can attempt. Nixon complied with the tape subpoena and then resigned. The precedent established was that a president must comply with a direct subpoena for evidence in a criminal case. But Nixon's compliance came not because the court could force it, but because the political environment made defiance untenable. The rule of law and the political arithmetic produce the same result. The current question is whether the political arithmetic eventually produces the same pressure here, not tonight, not necessarily this month, but over the accumulated record of the second term. 17 injunctions, the SCOTUS IEEPA tariff ruling, the Boasberg contempt proceedings, the court defiance pattern that Boasberg warned his colleagues about in February 2026, whether enough Republican senators eventually conclude that the political cost of continued defense exceeds the political cost of accountability. That question runs through November 2026, and the accountability record keeps building. The shadow docket dimension I mentioned earlier connects to something larger that the clips in this document capture but do not fully articulate. When emergency applications to the Supreme Court become the front lines, the clip's phrase, and an accurate one, it means that the normal appellate structure has been compressed. Cases that would ordinarily take months or years to reach the Supreme Court through the regular briefing and argument process are reaching it in weeks through emergency applications. Both the government and the challenging parties are using the emergency mechanism because the stakes of any single ruling are too immediate to wait. That compression creates a specific kind of institutional pressure on the court itself. The shadow docket was not designed for the volume it is currently processing. Orders issued without full briefing, without oral argument, without written reasoning. These are not decisions the court makes lightly, but the emergency docket structure does not require the transparency that full opinions provide. The clip makes the analytically precise observation. The Supreme Court doesn't have to tell us why it rules the way it does on emergency applications. That opacity means that compliance disputes are almost guaranteed because the scope of an order without reasoning is always contested. This is not a design failure. It is a design stress. The shadow docket is doing work it was not designed for at a volume it was not designed to handle. And the result is an institutional environment where the court's authority is simultaneously being tested more frequently and documented less clearly than at any comparable period. For the accountability story this series has been tracking, that combination matters. More frequent testing of court authority, less clear documentation of the scope of orders, more room for compliance disputes, and a president who has demonstrated throughout the second term a willingness to test where the practical limits of judicial authority sit. The Boasberg warning in February 2026, cleared by ethics review, permanent in the institutional record, described exactly this environment. Judges being asked to think about what happens if the president simply ignores their rulings. Not as a hypothetical, as an operational planning question. That is where the Jackson parallel lands. Not as historical drama. As a description of a constitutional structure that has been stress tested before, that has failed before, and that is being stress tested again in conditions that the founders could not have anticipated, but that their constitutional design was meant to handle. Whether the design holds is the question. The accountability record is what will determine the answer. I'm David Harper. Let me close with what the faithfully execute the law's obligation actually requires, because it is the specific constitutional text that the court defiance scenario implicates, and it is worth being precise. Article 2, Section 3 says the president shall take care that the laws be faithfully executed, not may execute. Shall. It is a mandatory obligation, not a discretionary one. The faithfully execute clause has never been litigated to a definitive resolution on the specific question of what happens when a president refuses to comply with a court order. The Jackson episode happened before modern constitutional adjudication developed. Nixon complied. Every other president has ultimately complied with direct court orders even when they disagreed with the rulings. The reason this specific constitutional text matters in the current scenario is that it makes the defiance analysis cleaner than it might otherwise appear. If the president has a mandatory constitutional obligation to faithfully execute the laws, and a court has ruled on what those laws require in a specific case, then refusing to comply with the court ruling is not an exercise of executive discretion. It is a failure of a mandatory constitutional obligation. That failure is what Article 2, Section 4, the impeachment clause, was designed to address: high crimes and misdemeanors. The founders' language was broad deliberately. They wanted flexibility to respond to forms of presidential misconduct they could not anticipate. A president who refuses to faithfully execute the laws by defying a court order fits within that framework by design. H. Resner 353 is in the permanent record. The constitutional text is what it is. The political conditions for executing the constitutional remedy are what the accountability story has been documenting all along. The answer comes in November. I'm David Harper.